Welcome to today's session. This is a webinar hosted by the East Africa Law Society and particularly the Young Lawyers Committee. And the topic that we're going to be running through today is effective advocacy, mastery of your role as a child advocate for effective legal practice. I'll just give a brief introduction of the session, and then I'll talk about who our panelists for today are, and then we'll start the webinar officially. So lawyer skills encompass a variety of hard and soft skills, both specific to the profession and transferable skills, and knowledge of law practices, protocol and regulations, logical thinking and solving problems are also involved. And for many years, it was believed that advocates were born with the necessary skills and that advocacy could not be taught. This school of thought has since changed over the years in as far as the basic skills of an advocate are concerned. And different law schools have impacted young lawyers with certain advocacy skills, which when taught correctly can be mastered by just about anyone. Effective advocacy then requires the ability to communicate and the ability to persuade. And trial or courtroom advocacy is that field that is concerned with making trial lawyers more effective in trial proceedings and administrative hearings. In trial advocacy, a trial lawyer is expected to exhibit the essential skills in advocating for the clients in civil and criminal courtrooms and before administrative tribunals as well. With the ever-changing legal practice landscape, there is constant need to build the capacity of young lawyers in the area of child advocacy to enable them to master their roles during the trials and how they can become more effective in their legal practice. So to guide us in today's discussion, we have two panelists. We have Senior Counsel Justice John Chigiti, who is a judge of the High Court of Kenya and a senior counsel, of course, and we've known him as a champion for the rights of and the welfare of intersex persons, as well as a teacher of trial advocacy. Welcome, Mr. Justice Chigiti. I'll introduce our second panelist as well. Yes. We have Ms. Linda Ikanza Linda, who is also a teacher of the law, and she practices mainly trial and advisory law in corporate and commercial practice. She has served in various capacities in both private and corporate legal sectors. And she's currently a partner at Amber Solicitors and Advocates, a law firm which specializes in commercial litigation, arbitration, and transactional work. So as a teacher of the law, Linda has worked tirelessly since 2011 to transform the teaching of trial advocacy and is the head of trial advocacy and moods at the Law Development Center in Uganda, and is the CEO of Justice Advocacy in Uganda, which provides trial advocacy trainings for the Uganda Law Society and other organizations on a pro bono basis. Welcome, Ms. Alinda. So to set us off, we'll start with the first point of discussion, which I'll direct us at Justice Chigiti. What are some of the common challenges faced by trial advocates, and how can they be overcome?
Thank you very much. Greetings to all the lawyers who are on board. And thank you very much for the generosity in the fashion and manner in which you introduced me. I'm very grateful and honored. Challenges are too many. The main one is fear. Fear is the greatest enemy that sits at the altar, which would otherwise be the altar of justice. Fear becomes the greatest threat that many would otherwise be potential counsel end up being victims of. So what does that mean? In order to be a good trial lawyer, you have to be a courageous person. we'll encounter a lot of challenges. The list is endless, but many of us end up losing our cases because of fear. It could be fear of the unknown, obviously, a law that you do not really understand. It could be that you're faced with an opponent who is probably a senior counsel. But always remember David and Goliath. The minute you slay the dragon, you're home and dry. Fear is a misconception that drowns us in the sea of doom. If you believe you're a coward, you will never get solutions. Maybe you're fearing appearing before that judge. At the end of the day, if you have a good case, you're good to go. Fear, many a times I've seen, is a challenge because it comes as a result of lack of good preparation. Squandered all the time that you had in the forest hunting monkeys and all manner of creatures. By the day of delivery in the courtroom, you deliver a skunk, stinks all the way home, and you lose your case. So Elizabeth, the greatest enemy and challenge that I have seen as an assault at the doorstep of many counsel is fear. Thank you.
Thank you very much, Justice Chigiti, for that introduction. And how do you think this challenge can be overcome, especially fear? I'll pass this back to Justice Chigiti, and maybe Ms. Alinda Kanza can contribute to the same.
I'll allow Linda to go first.
Justice Chigiti, I think your microphone is off.
Oh, all right, sorry. So that I don't consume the space fully, very early in the day, I was proposing probably Alinda could first comment, then I could again comment after she does. Thank you.
I don't know if you can hear me. I am struggling with my internet, but I've joined on a second device to be on standby. Just signal to me if you cannot hear me, and I will switch to the phone. Good afternoon, my fellow panelists, and good afternoon, our wonderful audience. It's such an honor for me to be here. And when I first met Justice Chigiti, I was a young lawyer. 2011, I think it was in Seattle in the US. And I must have been the youngest member that was training as an advocacy teacher. And it's so funny how time flies. I still feel like that young lawyer. I get surprised when people call me senior. I think that the odds are always in your favor as a young lawyer. You're always the underdog. When I appear against young lawyers, I'm always worried about what they have under their sleeve. The energy, the court sympathy, the vibrance. And it's funny how fear cripples us, and yet really there's a lot that is going for us. I think that the second challenge that I could speak to as a rider to what Justice Chigiti has already said is experience. Fear, the fear that Justice Chigiti is talking about comes from two places. The first place it comes from is, of course, we're human beings. We're warm-blooded mammals. For as long as we live, as long as we breathe, we will be fearing one thing or the other. It's natural. It's absolutely normal that you have to feel afraid. And in fact, if you're not afraid or if you don't fear, then maybe you don't care about what you're doing. Sometimes it's a good litmus test whether to see, are you prepared for the challenge? I don't think that there's any battle. I don't think that there's anyone that goes to battle without having that, that adrenaline that runs just to confirm to you that, yes, you're ready for the battle. So I'd like to say to some of my students that if you feel afraid, then it's because you're ready. And other than the normal fear that we go through as human beings, the second place where fear comes from is lack of preparation. So you sort of have to be sure what the source of your fear is. Are you afraid because you're a human being that has to be nervous, or are you afraid because you haven't prepared? You don't know your case well enough. You don't know the area of law that you're operating in. You don't know the judge. You don't know opposite counsel. You just have that fear that is a warning that you're about to be unraveled, And I've always found that the second source of fear you can overcome through practice. So I like, Elizabeth, when you said at the beginning that for many years, it was believed that you either had the talent for advocacy or you did not. And if you did not, sorry, choose another profession. If you did, oh, you're lucky. The question becomes, is it talent or is it practice? And what I have learned in my journey as a trial lawyer is that it is practice. It is practice. I don't expect to stand up and question a witness or address a judge something I have not already rehearsed, something I have not already gone over myself several times, to a point where I am nervous because I have to get up, but I have a plan. I know what I'm trying to do with this witness. I know my law. I can have a conversation with the judge without notes, without reading to him, and persuade him, because I have spent, if I am asking 5 minutes of his time, I have spent over 50 mulling over the arguments, mulling over what opposite counsel will say in response, what I will then say in response, where I will start and where I will end. And I think that lately, because our generation comes from a world of ease, we don't prepare as much as we used to. I think because everything comes so easily, you can get every authority just by searching on your phone. You can just ask on a WhatsApp group and you'll get all the answers you need. You can just copy and paste a precedent. We have skipped over the processes that lawyers, traditional lawyers, used to go through, that used to prepare them for the real work. And trust me, it is a lot of work. And because we don't have the experience, we don't have Justice Chigeti's experience, we don't have the experience that senior lawyers have, we must put in triple, double, quadruple the time. And yet that's not what our generation is carved out for. So I think that the next biggest challenge, other than fear, is that lack of experience and not knowing how to make up for it, not having concrete strategies that help you navigate a new terrain in a way that will ensure you come out successful. I hope I haven't been speaking to myself this whole time.
We had you, Linda. And maybe still sending the same question to Justice Chigiti. Do you think this aspect of fear, like Alinda said, is an aspect that comes out of ill preparation? As a judge, have you had people come before you and you can tell that they are already frightened, and how have you guided these people?
Yes, indeed. And what I have seen is a very complex process. Why do I say so? I have seen counsel present in all manner of ways, and I have been able to tell that this person from deep within is suffering, is under siege. You will see the telltale signs of fear. They're trembling, they're shaking, they're not coherent. They can't give you eye contact. They are not able to locate the applications. They are not able to identify their pleadings. They can't tell what their case is all about. They are agitated, they are edgy, they're irritable. They can't nail it. They don't know their opponent's case. They don't know the issues. They want to run. They're impatient. All those are complex entries that culminate in the conclusion that this person is suffering from fear. So you'll find the advocate in your court does not know their case, does not know their theory, don't seem to appreciate the facts of their case, don't seem to connect the facts to the law. They're all over the place. As a young lawyer, those things I've mentioned are going to come your way. Expect them, because they're not foreign. Like you heard Linda say, if you don't have fear, if you don't experience fear, there's a problem. The problem, big problem, comes in when you keep repeating the same thing every other day. Every time you appear in court, you're recycling yourself in the fashion and manner of no eye contact. The judge cannot hear what you're saying. It's the same thing repeating itself. You don't know the facts of your case. It is good to go through that fear once, twice, so that you get to test yourself, appreciate who you are, so that if you find yourself in the state of fear, do not condemn yourself on day one. The problem is when it becomes a habit, a tradition, a lifestyle as an advocate. Do not repeat those things. Do not walk in the valley of fear for long. And that's why we encourage mentorship. That's why we are in this conversation today, to make us better people who will not repeat, go through the tunnels, go through that dark, deep, rainy forest every morning they wake up. You have to realize that you have to graduate into an advocate who is better than who they were yesterday. It's a choice. Yes, indeed, you can exit from that pit of fear. Make that choice. Nobody will do it for you. Thank you.
Well, thanks. As we move to the next point of discussion, which is about preparation, I think, Linda, how best can someone prepare from your point of experience, and juxtaposing the same with case analysis? Can you please give us a view on how best an advocate can be prepared to be an effective trial advocate?
Thank you, Philip. So, as you all know, last week we lost a really great lawyer, great judge, great man, Justice Kenneth Kapuru. And I remember one of my early introductions to case analysis was from a conversation I had with him. And we were talking about how you decide if you're going to appeal a case that you've lost. And he said to me that in his career, in his practice as a lawyer, he appealed every case he lost. And I said to him, really? And said, yes, because by the time I file a case, I have reason to believe that I must win it. And if I do not win it, I'm going all the way to the last appellant court, because the amount of preparation that I put in before I file a case helps me decide if it is a case that I can win or lose. And so that's the mindset that every great trial lawyer should always have. That by the time you decide that this is a case I'm filing, you should have analyzed it. And the first place that we analyze from is research. Because usually if a client walks up to you and tells you what their issue is, as a golden rule, you shouldn't think, or you shouldn't even advise or draft pleadings without going through all the Supreme Court cases on that particular topic, all the Court of Appeal cases on that particular topic. You see, the Court of Appeal and the Supreme Court see these cases through very long lenses way beyond the first court of hearing. You pick up things that you didn't even realize is where a case would end up when you start it in a lower division. And if you haven't researched, if you haven't gone through those authorities on those particular, you have no business drafting. You have no business assuming that the one or two high court decisions that are in your favor are what will cushion you against all the unforeseeable tornadoes that are going to come your way. So preparation begins with being knowledgeable widely in a particular area before you decide if you're going to file that particular case or not. And I know I'm talking to a generation of lawyers that believes that, court is like a sorting, like how you have bins, there are some stones, there are some leaves, and you're just checking to try and get out the bins from, sometimes we treat the court like that. We just feel that, we shall see where this thing goes in court. And that cannot be how you analyze your case. So case analysis, as we traditionally teach it in law school, begins with a cause of action and its elements. Why? Because remember that you're going to be telling or persuading the court guided by the elements of that cause of action. So if, for example, you have a case where you're saying that there is fraud, you must know as a bare minimum what the definition of fraud is and how you're going to prove each and every one of those elements. Case analysis is really taking your client's story, whichever form they've given it to you, and analyzing whether in the facts and the evidence that you have, you're going to be able to fulfill what the court requires you to fulfill in order to get the remedy that you want. And I think that that discipline is not common, but if you do that, you will clearly, as a lawyer, have your strengths and weaknesses of the case revealed just by going through that process. Because every fact that makes up your client's story is either advancing it or a weakness in it. And I think that from where we come from the good program that we run with Justice Chigiti is part of the faculty in Kenya. We call those good and bad facts. Good facts because they're in your favor, bad facts because they're not in your favor and they can be used against you. And as you case analyze, it even goes beyond just the facts. You look at your evidence and try to prove it is this evidence going to stand up the test of cross-examination? Is it going to be admissible? Does it have some weaknesses that I need to firm up? Do I need discovery from the other party because I don't have authority to tender it? There are so many questions at the back of your mind that you have to go through. What kind of weaknesses do I have? Do I need all of them? Can one of them speak for the rest? Who is going to be countering their evidence on the other side? And then, of course, the law, because case analysis cannot be complete if you haven't looked at, maybe there's this new authority that is going to be the roadblock in your road. Maybe there's a principle of law that the other side is going to advance that is, you thought was your sword, but for them is a shield. So case analysis is really exactly that. Analyzing every part of your facts and evidence to make sure that it will be able to get you the remedy you need. And if you do it very well, for those of us that work in firms and in teams, it's a good resource for everybody that will deal with your file. Because I think we all know as trial lawyers that our minds are freshest and sharpest when we first meet a case. And in that moment of being very fired up and being very moved and inspired by the client's story, some of those thoughts never come back if you don't record them. And so the structure, a good structure of a case analysis enables you to capture all those thoughts in fresh and usable ways that can see you through a trial. So I don't know if I've answered you, Philip, but case analysis is that analysis of all the evidence, all the facts, as in terms of how will it happen in court and of all the legal arguments that will support your case to be sure that you're coming out of this victorious.
You're not just answering me, you're answering over 300 people on call. So it is just so insightful, and I believe they're taking down something. I'll call in my colleague, Elizabeth, but I think the good judge should also highlight something on case theory.
Yes.
Case theory, because it's an area that we also need to know whether the justices are really convinced, and when do they pick the conviction to say that this advocate is really into his case. Over to you, Elizabeth.
Right, so we can start with that. Maybe Justice Chigiti can take us through the question on case theory, and then we will follow up on the issue of credibility with the bench.
Thank you. You will allow me to do a reverse gear and walk into the park where Linda was dancing.
It is fine.
Very nice presentation, Linda. A couple of years ago, I put together a few words and posted them on social media about trial advocacy. I didn't know that it was harvested and it is being harnessed even at the judiciary. I'll just tell it to you because I've managed to smoke it out from my phone. And if you're keen, I can share it with you by way of a forward. It goes like this. Trial Advocacy Snippets by John Chigiti SC. Case analysis is very helpful. What do you do as an advocate? List down the facts, then list down the good facts, followed by the bad facts. Identify the relevant witnesses, documents, and identify the issues. Sit back, relook at the Limitation of Actions Act, do your due diligence. Look out the applicable laws. identify the elements of the section, the regulation, or the article. Don't leave until you identify the jurisdiction or the choice of court. Understand the burden and the standard of proof. Look into the applicable precedents and case law. Then craft appropriate reliefs. Assess the implementation framework. Draft your pleadings. Then draft your opponent's pleadings. Take a break. Reread your pleadings. Go to the theater and act the role of the scriptwriter, the actor, the villain, the director, and the audience as you prepare your submissions. Write a judgment for yourself. If happy, and if you're happy at this point, then proceed and file your case. Thank you. So that's a very small journey into a small arena where Linda was dancing, where you young advocates can twist and turn and do skating and jump around and play as you do that journey, as you do the case analysis, as you understand your own case, as you walk into the judgment you have written, run back into your submissions, play the theater, be the audience, be everything. Remember, at the end of it all, you will be the storyteller. And he who tells the best story wins the case. Thank you. But it's not done yet. You cannot tell a good story if you don't have a theory. You cannot be credible if you have a multiplicity of theories for your case. If you're going to sway and swing in all manner of directions to suit your convenience, you lose credibility in the eyes of your judge. So as Linda told you, when you get a folder, a brief, you must identify your facts. Identify the good ones, the bad ones, and then ultimately ask yourself, how do these facts connect to the law? Generate a hybrid outcome by saying that the law is not as clear as we always say, but you're going to generate a story that is going to be persuasive, that is pegged on the facts, that is pegged on the elements of the law that you're speaking to. For instance, what is theft? The taking of a thing capable of being stolen with the intention of forever depriving the owner. Those are the ingredients of theft. Look at your facts. Was your client present? Was there anything stolen? Was there an intention? Was there an actus rea? Then ask yourself, because you're defending your client who is likely to get convicted, how can you present a case where the judge is going to look at your client differently, not as a thief, but as a person who was assisting prevent a crime? No wonder he was at the crime scene. No wonder something was stolen. Yes, it was stolen. That is what he was helping recover. He had no intention. His intention was different. He was at the place where the crime took place, doing his usual thing, selling bread at the market. And your client goes home because you had a theory that is credible and believable, that is selling, that is compelling. And your judge smiles and tells you, counsel, your client is acquitted. That's it. Thank you. There's no rocket science.
Thank you, Justice Chigiti, for that very informative addition to that. And yes, you've actually dealt with the next question, which was how do trial advocates establish credibility with magistrates and judges? So we'll go on to the next bit, which both panelists can answer, about the role of storytelling. We've touched on that a bit, the role of storytelling in trial advocacy and how it can be used to persuade the audience. Yes, we can start with you, Miss Alinda.
Okay, all right. So I didn't realize for a long time that when we say storytelling, at least here in Uganda, what some people hear is made up stories. Because, you know, growing up, when it was story time, or when someone says, let me tell you a story, they are dealing with something that they've made up in their minds. It's not a real story. So the beginning part of applying storytelling to trial stories is to just warn ourselves that when we say story, we're not saying go and forge and concoct facts that are in favor of your client. No, we're just saying that if you had a chance to tell the facts involving your client's issue in court, think about it as a story. Let it be in your mind once upon a time. And if I just continue with Justice Chigiti's example, I often went to a market to fend for him and his siblings, so that in the eyes of the judge, this person is humanized and their story is relatable, because that always makes you more persuasive. You cannot, you see, at the end of the day, we are all human beings, and human beings love a good story. And storytelling is the grandmother of all our knowledge. If you think about when you were a child, a lot of the lessons you learned through stories. But you see, when we tell our stories in the courtroom, we tell them from the lens of the law. So we don't, there's a difference between the story that someone in a theater as part of a drama group is going to tell from, it could be the same story. We could both be telling the story of a theft in a marketplace, but I tell it as a lawyer from the position of my theory, what Justice Chigiti has just been saying. I tell it as a lawyer because I am speaking to a certain course of action that has certain elements that must be fulfilled in order for a remedy to be granted to my client. So your question was, how does storytelling help us as a technique? What is its role in a trial advocacy, and how can it be used to persuade an audience? Its role is in humanizing our clients' stories, making them relatable, making them more persuasive, but that does not give us permission to depart from the legal requirements, because after all, it's a court of law. After all, you're still talking to a judge, and for Kenya and for Uganda, for all our East African benches, we are bench trials. We're going to be persuading a lawyer. We're not going to be persuading a normal person. So I see that so many times, because we are in story mode, we think that we can just tell plain stories that are not benched or anchored in the legal requirements. So the theory of your case is the compass when you tell a client's story, but part of what telling that story requires is that you know the bench, you know the judge that you are trying to persuade. at the end of the day, you're trying to persuade a specific person that you should have researched. You should know that this particular judge is probably a women's, she's a member of FIDA, maybe she will be compassionate about the fact that this is an orphan. So this is how I'm going to
Right, we seem to have lost Miss Alinda there for a bit.
my
Yeah.
computer has, can you hear me?
Yes, you can hear you now.
Yeah, so I was saying that at the end of the day, you must package your story for the specific audience. And storytelling comes in to give us all the techniques that we need for us to captivate, for us to persuade, but it doesn't give us the permission to let go of the law as the compass, or to let go of the setting of a bench trial, and to forget that at the end of the day, this is a legal mind that I am speaking to. So as a result, a lot of the dramatics and the theatricals that we see in these movies, when people are persuading juries, will not apply to our bench trials. If you're trying to persuade Justice Chigiti, he might indulge you because he loves a good story and he comes from the trial advocacy world. But if you're persuading, let me say, for example, Justice Madrama, you better speak the law to his brilliant legal mind. Otherwise, you're not going to be persuading. And so when you think about a story, if I was a parent telling a story to my children, I know what my children love. I'm going to be persuading them specifically. I'm not going to prepare as though I was speaking to an audience I do not know. I'm going to package it to persuade them as children. I'm probably going to be more playful. I'm probably going to be seated on the ground with them and not talking at them from my height against theirs. I'm going to think about what will appeal to them. And that work does not go away when you're dealing with a judge. You must know the audience you seek to persuade in order to apply the techniques of storytelling to persuade that audience. So just because you have a good story doesn't mean that you're going to forget about the legal requirements, about your specific audience, or about the setting of a bench trial. And I hope that Justice Chigiti can just jump in and cover some more context for this whole storytelling in the courtroom idea.
Yeah, Linda and your storytelling techniques, always interesting, always amazing to listen to. Indeed, there is a lot. You must always walk with the notion that your judge is waiting for you to tell them about your case. The judge is a neutral party. The judge is not going to walk into your stage to smoke the story out of you. So you must tell your case to the judge. And some of these opportunities come through, for instance, when you're doing written submissions, when you're expressing yourself in writing, when you're expressing yourself in highlighting by speaking to the court, when you're doing your opening address, when you're doing your opening statement. So ultimately, this thing of storytelling is indeed real. When I first heard of that thing, it was from a Supreme Court judge in Washington. And she told me, she used to call me, she still calls me, Chigiri. He who tells his best story wins the case. I kept it, but at first I just looked at her and wondered, hey, what's wrong with you? Today I'll tell you, it's everything in the courtroom. Persuasion. So how do you achieve that? You achieve that by, first of all, being present. Eye contact is a very critical tool in your storytelling. Your gestures, your body must speak alongside your heart and your eyes. You must be audible when you're telling your story. Make sure that you are telling a believable story, not an unbelievable story. It must be relevant. Don't just tell the quote things which have no value, have no relevance to the issues. You must be precise, concise. You don't have the whole day to tell the story. You're not in the mountain or at the seaside or besides, your friends just chatting away. You must remember that you have to be simple in your storytelling. Don't make it complicated. Avoid those heavy words, maxims, jargon. They have no place in the storytelling journey. The simpler the story, the easier it is for the judge to understand the story. Within no time, your judge has it. If you use the right tone modulation, don't just go in a monotone. Remember, if you're boring, your judge will travel to the hills and leave you in the courtroom in his mind. Thank you.
Thank you very much, Justice Chigiti. There's a question directed to you from one of the audience. And the question is with regards to the use of open statements in court and whether you allow advocates to use open statements if they so wish, because the person asking the question has been in courts where this has been forbidden.
Indeed, it's not forbidden. Maybe it's what you have done in that court before that is making your judge tell you it's forbidden. Have you gone and made a cocktail of yourself in that courtroom in the name of an opening address? Maybe. Or maybe it's your neighbor, your colleague. Well, persuade your judge to listen to your opening address. But just like we said, the judge will shut doors tomorrow, pegged on what you do today. Stand there and in a flash of a minute, deliver your summary of your case. By the time the judge knows, you have done your opening address. You don't have to do 30 minutes, 15 minutes. I mean, it's the table of contents of your book. Tell the judge in a flash. And before you know, the judge will tell you next time, counsel, I want an opening statement. It's possible. It's not illegal. I'm sure your procedure laws, criminal and civil allow. So do it, but be disciplined. Respect the court. When the judge tells you he has allowed you 1 minute, stick to that minute. And what I used to do, given a minute, I'll do 58 seconds. Credibility. Let the judge see that you can stick to what they asked you to do, the timeline that gave you. So yes, indeed, it's important. Keep pushing. But of course, look at the judge's list. If the judge has 50 matters, you know you'll not push your button very far. If the judge has 5 matters, persuade the judge to listen to you. Make it a habit amongst your peers. And as you heard Linda mention, we have the trial advocacy training. We have a family. We work together, birds of a feather, so that if you're in that courtroom, 20 advocates, you'll see a minimum of 10 trial advocates converted, trial lawyer converted, advocates with their badges. So you try, the judge says no. Elizabeth goes next, she tries. The judge says no. Philip goes next, and the judge is like, hey, what's going on here? Because you're converted, the judge will say, all right, counsel, I allow that. So that when Manyara comes next, David, Philip, everybody, the courtroom is all an opening statement. We can do it.
Thank you very much. We'll go on to the next question. And I'd like to encourage all the listeners to ask questions, to either use the chat box or the question and answer slot, and we'll deal with them as we go along or at the end of the session. So the next question, which we'll direct to Ms. Alinda, is about effective techniques for cross-examination. What are the most effective techniques that you can employ in cross-examination?
So when I went to law school, I remember this was one of the questions we used to prepare so much for at LDC. Our trial advocacy exams were closed book, and like you had questions, and it was a common question: discuss the 13 laws of cross-examination by I rank. And we crammed those 13 laws, and then when I was done with LDC, lo and behold, I found myself in a courtroom being required to cross-examine a witness, and none of those 13 laws could come save me. I was stuck. I was putting it to the witness. The witness was saying, you can put it wherever you want, madam. I've told you, that is my answer. And I just felt so betrayed by my entire legal education. I felt as though everything I had been told was a myth that had just evaporated. So over time, I have narrowed down the most important things about cross-examination to be about 3. The first technique, or the first thing you have to understand about cross-examination, is that it might be more than just the negative goals that we've come to expect. If you go into a cross-examination, your only goal being to tear down a witness, to destroy him, to discredit him, and all those other DDDDD's goals, then you are only using, if let's say it was, if it was, let's say a tool, you're using only 10% of its potential. The most important goal for cross-examination is to advance your side of the case through an opposite witness. To think about all the positive aspects of your case, all the reasons why you should win, and have them confirmed by the opposite side. Because you see, when people tell their stories during examination in chief, when they write their witness statements, they only go over the glossy sides. They only cover the sides that are in their favor. And yet there will always be another side. And so for me, I think it is one of the greatest books on cross-examination says that cross-examination is the greatest engine ever developed to test the truth. So it is an opportunity for you to tell your side of the story through an advanced witness. That's the first goal. Go into cross-examination thinking about, how can this witness advance my case? What can this witness say that supports our side? Don't go into the cross-examination thinking, how can I paint this guy so black that the court won't be able to see him? That's not a goal, unless that goal is going to advance your case. So many times it doesn't. What happens if you have to cross-examine the Pope or a bishop? You might not have so many lies that he has told, but also just because someone has told one lie, that doesn't mean that their whole story is not believable. So I think that for me was the most liberating thing I discovered about cross-examination, that it is not my job in cross-examination to make the other side look bad. It's my job to use them for my side's case. Now, once you go into cross-examination with that mindset, then the second thing you want to do is to keep it to the facts. cross-examination, someone said that, I said to a group of friends of mine, we were talking about cross-examination, and I said to them, cross-examination for me is a surgery of the facts. And they said, oh, Linda, we should write that and put it somewhere on a chart. Why is it a surgery of the facts? If you don't know the facts, you're going to end up arguing with the witness because you're going to be talking about your opinion, your interpretation, your analysis. It's the facts. Because if you stick to the facts, it's easier to control a witness. It's easier to bring them to use those facts to demonstrate why your client should win. So when I prepare for cross-examination, I start out with the specific conclusion that I want the court to draw from a certain set of topics. So maybe I'm looking at 3 points that I would like to make in my closing submission. And for each of those points, I will write down as many facts as I can find that confirm or support that particular point I'm trying to make. So you're going to find that I have like so many plain papers, and at the start of each of those papers, I have all these small facts that lead to that particular conclusion. So that's what cross-examination is. It's a collection of all the facts that support the specific conclusions you want the court to make at the end of a trial, at the end of that witness. So it's about the facts. So in how you present those facts to a witness, you must keep it at 1 fact per question. And this is absolutely important. You know, witnesses in cross-examination are very evasive. They're going to be looking to say no when you want them to say yes. And this is where leading questions come in handy. This is why the Evidence Act allows us to use leading questions. Because if I have leading questions, if, for example, the point I'm trying to make is that Justice Chigiti is smart today, I'm not going to be asking him about the conclusion of whether he's smart or not. I'm going to take the facts that lead to the conclusion that he's smart or that he's dressed smartly, and I'm going to break them down one by one to build onto each other. So it will be, Justice Chigiti, you're wearing a shirt, blue shirt. Justice Chigiti, are you wearing a blue shirt? Justice Chigiti,
Yes,
can you
I
hear
am.
me? And on
Yes.
that shirt, you have a tie.
Yes, I do.
The tie is blue, navy blue.
Yes, it is.
And then you have a jacket on.
Yes, I do, ma.
The tie has dots. Is it dots? I can't see clearly. Is it dots or is it?
Yes, it does.
Now, imagine if I wanted to put those facts to Justice Chigiti, and I say to him, Justice Chigiti, you're wearing a shirt and a tie that has squares on it, and you have also added on a jacket. Am I right?
No, you are wrong. I'm not wearing anything like that. In fact, what I'm wearing is a gray jacket, and I have a pair of pants which are colored, multicolored. And yesterday my tie was eaten by the cow. And
you see what I just did to Justice Chigiti is that I want him to say yes, but I just threw at him so many facts. And most witnesses won't even be as kind as Justice Chigiti to explain what they are objecting to. They'll just say no. And then you'll see a witness saying, you see a lawyer saying to a witness, you're not wearing a suit? You mean you're not, you mean what part of my answer are you saying no to? Well, the problem is yours, sir. You have congealed so many facts together. You're trying to get a specific answer from a witness. And now when they say an answer you don't like, you don't know where to go to correct it. But if you've been building your facts one onto the other, when a witness says no, you know that he's taking issue with the time. And you first correct that before you keep on building to that conclusion that you're moving towards. So for me, I think that cross-examination, one, has positive purposes. It's always to advance your case. It doesn't have to be through destroying the witness. Two, it's about the facts. And in order for you to best control those facts, you must present them one at a time using leading questions. And three, you must tell enough facts to develop a particular conclusion. And if you go into cross-examination with just those small goals, you're going to find that you will achieve more than just hoping to argue with the witness so they can look bad. Many times you're the one that ends up looking bad.
Thank you very much for that very good breakdown. I will hand over to my co-panelist, Mr. Munabi.
It gets interesting. Ivan Younger has said cross-examination is it's a surgical strike, not the invasion of Europe. Just like the good judge has been cross-examined, I think it is something that we can pick up on as a skill. So many prominent people in this field have made it clear that it is a skill that you practice over and over. The good justice previously said you can easily and ably identify someone who has done trial advocacy training. I can testify to that in one of my very few appearances after the trial advocacy training with Justice Advocacy Africa, Justice Advocacy Uganda. A colleague of mine said, "But you, man, you always make a fool of yourself, but you're so good in this thing." It just tells us that there is a lot needed to be done to yourself to develop your skills so that you're a good trial advocacy lawyer. And we shall get a few highlights about cross-examination from the poetic justice as he takes us into understanding how to effectively control hostile or handle hostile witnesses as you make your case before court.
Thank you. I'm honored. Accolades coming my way. Thank you very much. Thank you, Linda. Always nice listening and listening and listening. That's the beauty of trial advocacy. Every time you speak, you learn. Because it's learning by doing. You don't sit in a classroom to listen to boring lectures. We teach trial advocacy by doing. It's the best way you'll never forget. Yeah. So just to top up on the cross-examination or over and above where Linda dropped it, when I was in practice, and I want to see you doing it in my court, your cross-examination must not be cross. Keep anger away. Cross-examination must not be cross. When you come into the arena of cross-examination with anger, you lose your credibility. 2, I am going to smile if I see cross-examination that is pointing at the issues. 2, I'll be happy if I see cross-examination that is within the pleadings, means relevant. Your cross-examination will be shining if you're moving towards your reliefs. Good cross-examination must speak to the law. So what you're doing in the cross-exam, guided by those pillars, your pleadings, your issues, the reliefs, and the law, you're preparing your submissions in advance. So that once you're done, when you sit down to prepare your submissions, closing arguments, they will so easily connect with the answers that came through cross-examination. Because those are tested answers. They're not like chief, they're tested. Number 3, do not have many wives. I don't know what you call them, I suppose the wives in Uganda. Do not be polygamous. What am I saying? Do not have 5 wives. What am I saying? I'm sure all are wondering. It simply means that during cross-examination, avoid the W's. What are those? Do not pose a question that has the word who. When? Why? How? Explain. Describe. Those are your worst enemy questions when you're doing cross-examination. Why? Simple. The minute you ask Linda, which I shall do, Linda, why are you here?
So I was
Yeah.
going about my day, I can't remember when, was it last week? Should I go on, my lord? How much time do I have for this question?
All right, stop. There she goes, storytelling. I gave her the blank check. Instead of asking that, I'll ask her differently. Linda, you are attending the trial advocacy skill today, training session today, right?
Right, my lord.
Because you are invited by the East African Law Society, correct?
Correct.
And you love trial advocacy.
I love trial advocacy. I do.
How sweet. Look at how nice it is. Yet, I'm cross-examining. So good people avoid the many wives. Who, what, when, why, describe, tell, avoid all that. Instead, make statements when you're asking questions. The next thing, always know your answers before you pose the questions. Do not ask a question whose answer you do not know. That is going to be a crime because the witness will take charge of you. Next thing, in Africa, we like putting it to them. I put it to you. Linda, let's put it to you. Let's see how it looks like. Linda, I put it to you that you're an evil woman.
You can put it wherever you like. I am not.
Linda, I put it to you that you're a thief.
Protection, my lord.
I put it to you that you are the custodian of the stolen jewelry. I put it to you.
If you like.
Well, what happens when you put it to the witness during cross-examination? What I have concluded is that that is the point when you start losing your case. Never put it to the witness. The answers have no value. Many a times the witness will put it back to you. Then it becomes a put and put, I put, you put, you put, I put. You lose credibility. Next critical thing, exit once you are done. Remember, this is your enemy. It's not a bonfire. Once you're done with what you went for, exit like a commando. You invaded the enemy's camp, exit once you get the results. With the cross-examination, witness is not your friend. And finally, which will connect to the answers to what I was asked to speak to. Do not lose control of your witness. How do you retain control? Your witness, who is now the witness who your cross-examination, I'm calling them your witness, is because you have to ensure that you get answers. Sometimes they become difficult. Yes, they do, because they are under siege. They are busted. You've held them by the neck. They feel cornered. They'll fight back. What do? Remain calm. When invited to a fight, do not fight. Maintain silence when the fire comes from the witness, if at all it comes, because it's a difficult witness. Restrain yourself, abstain from speaking. The court will monitor the demeanor of that witness. If the witness is becoming too difficult, shelve that question, put it on a clipboard, go to another question, find your way around again and come back to that question differently. Many a times they'll not realize what you have done because they're angry, they're bitter, they feel betrayed. Probably the advocate didn't tell you what to expect, but you're back there. You have hit, you have your results. The third method to deal with such witnesses is by repeating the question again and again and again. At some point, you can ask the court to assist so that the witness gives an answer. Okay? So there are very many small entries in terms of retaining control. The other one would be what Linda told you. If you ask one question per fact, you'll keep getting results. Build your story with one question, one fact. Eye contact during cross-examination sells. You have to be courageous. Remember the fear we started off with? If you have fear this time round, if you walk with fear, you will drown in the sea of answers of the witness. So be courageous, eye contact. Ask the questions looking at the witness in the eye. Finally, how do you retain control? By being firm in your tone. This is not your friend, remember. Be firm with your questions. Thank you very much.
Very interesting, very interesting. But you see, the good judge, we are in a generation, like Alinda said earlier, we are in a generation that is in fear of preparation. We have also so much adopted to writing submissions. There's a question to that very effect. One participant saying, courts have adopted the use of submissions, and you find that most times when you go to court, opposite counsel will be quick to ask for filing written submissions than going the trial advocacy way. I think it is something that is also another challenge in the way of building trial advocacy skills among advocates. So the same takes us to our next question, which is about how to effectively use your skill vis-a-vis the visual aids in the courtrooms these days, because it's technology versus the day-to-day demands of a trial advocate. It is a question that you will both address as we go to the next part of the session. I'll start, you can start the good judge, then Alinda will come in.
Thank you very much. Indeed, many procedures in our courts are going written submissions. But I'll tell you one thing. What I have learned through trial advocacy is so critical, so relevant in all walks of life. It's not limited to the courtroom. Back to the courtroom. If you think that we are going to lose the trial advocacy skills into the submissions platform, submissions are part of trial advocacy, for your information, so that you will realize if you cannot prepare your case well, case analysis right from inception, then you'll not prepare good submissions written. What does that translate into? It means simply that you are going to be a mess in the court the day the judge will tell you, come in and do highlighting of your submissions. You will drown there. You cannot do voice projection. You have no eye contact. You have no tone. You have no organizational skills. So if you didn't attend the trial advocacy skills training, that will be a Waterloo. Do not neglect, do not abandon trial advocacy. Some of you might practice in the criminal courts. Examination chief, cross-exam, re-exam. You will not do written submissions on that, my dear. Just embrace trial advocacy. You might find yourself practicing in tribunals, the Yugoslavia kind of tribunal, the ICC kind of platform. They have their rules of procedure, and trial advocacy is playing out big time in those fronts. Finally, as a judge, if you become a judge or a judicial officer, magistrate, if you do not know the skill, the law, the procedures around trial advocacy, chief examination regulations and rules, chief exam limits and bounds, the scope, the procedure out there, then you will suffer at the bench. So either way, just embrace it. You will not lose. Instead, you'll become a better person. And you can imagine communication, the skills of communication, which is a key component of trial advocacy, will not be honed on a pen, on a paper, in a pen, in a paper, in submissions. It's going to be honed when you can stand up and become the great orator, the great person who can speak to the judge, who has a language that can be understood by the court, who is able to deliver their case. Do not be cheated. Trial advocacy is going nowhere. It is here to stay. It's actually moved to the appellate court, it's moved to the Supreme Court. We see submissions, counsel stand up to deliver their submissions, highlights. If you do not have the communication skill, if you do not have the technique, you are going to have it rough out there. So it's not just limited to the magistrate's court, it's all over. Once you become a member of the bar, it becomes part of the trial journey. Thank you very much.
Just before Alinda comes in, let me chip in a little. There are so many questions on how to persuade the judge in submissions. I'll inform the audience that we had last year, about February, we had a very nice session on the art of submissions by Kamau Kalori. You should visit it on the ELS YouTube channel. And maybe Alinda, as you come in, chip in something small about impeachment. Alinda?
Sorry, could you just recap for me the question?
The question was,
Submissions highlighting.
The question is on my point was
what I had Justice Chigiti speaking to was the whole written versus oral and how you balance the two.
Exactly. But I wanted you to also chip in something on impeachment, because it's an idea that is also impeachment. Yeah.
Okay. So I think that Justice Chigiti has already explained to us how you have a blend between written and oral submissions, because you see both have their pros and cons. And as a lawyer, you want to ensure that your client gets the advantage of both. So especially as someone just asked in the chat, how do you make sure that the court records you if they're not writing? A good way to do that is to have filed your submissions, because if everything that you're going to say to the judge is already in a written version, it's easy for you to have a conversation with the judge because you're not worried about capturing every detail since it's already in the written version. And again, someone asked in the chat, what is highlighting? Highlighting then becomes more of a summary of what you've already covered. My lord, on this first issue, we ask that you resolve this issue like this because of reasons 1, 2, 3. The evidence we have led, we've showed through this witness, through that exhibit. You know, you're just paraphrasing and summarizing and having a conversation with the judge. And I think that, again, one of the questions that came up now that we're talking about submissions is what do you do with the interruptions? And that's what I like about the oral version. I like to think about interruptions from the bench as a gift. I would rather a judge that interrupts me than one that just looks at me like this and probably even smiling and then in the end finds against me. Because the questions that the court has give you an opportunity to enter their mind and see where the doubt is for them, where the questions are, so that you can try and answer them. And I know it's many times is irritating or seems unfair because sometimes they don't even let you finish your point, but they are trying to send you somewhere and you must go there willingly. Now, that's what highlighting is. Just a highlight is, if you remember when we used to prepare for exams where we would highlight parts of the book, surely if you're highlighting the whole page, then there's a problem. But there are those important aspects that you really don't want to miss. Those are the ones that you spend the precious court's time on if you have a chance to address them. The rest of it can be in the written versions. But because we have written versions, sometimes we're tempted to read. You know, if these days even news anchors do not read verbatim, word for word, how can you, the lawyer, then read to the judge? Nobody has that time. Have a conversation. Persuade the judge. Now, I just want to go very quickly to impeachment. So when you think about cross-examination and the many goals that it can have, cross-examination generally is, you know, bring out the positive aspects of your case through an opposite witness. But sometimes there will be aspects that deal with the witness's character, the witness's knowledge, the witness's experience that you want to discredit. So impeachment is that. It comes from that English word impeach. You know, to impeach, you've seen members of parliament that are impeached, presidents that are impeached. It's like a vote of no confidence in this person. Maybe this person is saying that they are a good eyewitness, but you know that they were not actually facing the direction of the accident when it happened. They just turned, and by the time they turned, the car had already smashed together and they couldn't tell you, as well as you who wasn't there, they can't tell who was in the wrong. So in impeachment, what you're trying to do is to bring out those reasons why someone's knowledge should not be relied on. Someone's evidence should not be relied on. There are many reasons why we impeach witnesses. You can impeach a witness because they're biased. because they're prejudiced, they have a prejudice against. So you've seen, for example, experts who always appear for insurance companies and always say that the claim should not be paid. Surely they're probably paid by that side of the case and always render an opinion in favor of whoever pays them. So when you impeach a witness, it's because you want to bring out the reasons, the negative reasons why their evidence should not be taken on surface value or should not be believed. I think that the commonest thing that we practice is impeachment on prior inconsistent statements. So maybe the person at the time of going to the police and recording a statement said one thing, and today in court, they're saying something totally different. So what you're trying to show the court is that the previous statement is what the court should believe, not what they just said in court this morning. And that process is very elaborate and it's very detailed. I might not be able to go into it, but whatever you're using to convince the court to believe should be more believable than whatever the person has just said there. So you must spend time to demonstrate to the court why they should believe that statement and not what the witness has just said. And that's just impeachment. It's a very broad area and it covers so many reasons. You can impeach someone just to demonstrate that they don't know what they're talking about. Maybe they are an expert. Let's say, for example, they are a doctor, but they are here to testify on something that requires a surgeon. So they don't really have the specific expertise that you need to determine causation in this particular case. But that's generally impeachment. And like I said, you must reserve it for only when you will succeed. Because every time you set out to impeach a witness and you fail, guess who you impeach?
Just a second, Alinda. Just a second, Alinda. The good judge seems to have another engagement.
Oh, okay.
I don't know if you would impeach him before he leaves. Elizabeth?
Yes, he might have already left. I'm not sure,
Oh.
but he might have already left, yes. So maybe if he joins us towards the end, that's okay. But I think he had a different engagement. If he comes in before the end of the session, that's fine.
All right. Elizabeth, gets interesting, but you can take it on.
Yes. Right, we interrupted Miss Alinda. Apologies for that. But maybe as she continues,
No, it's okay.
we can also tie that in with the next question about effectively dealing with objections raised during trial.
Yeah, so I was just saying that you have to make sure that you will succeed in your impeachment, because if you fail to impeach a witness, you impeach yourself as a lawyer, because you've set out to make this person look bad. And if you fail at it, automatically you're the one who's going to look like a fool. You're the one who's going to look like you were just, trying to falsely accuse this person of malice or prejudice or bias or not knowing what they were doing, when actually you're the one that doesn't know what you're doing. Yeah.
Thank you very much. I think you'll handle both the last two questions, and then we'll go to the question and answer. Then the next question is about objections, right?
Yeah.
And how trial advocates can effectively deal with objections that are raised during trial. Right. The good judge is back.
Yes, I had a meeting with my principal judge, but I have missed the flight. Courtesy you. He has left. Tomorrow is another day. It's gone.
The good principal judge knows that you're doing very important work with the bar.
Look at you and persuasion skills. All right, let's go on.
Yeah, so I think that the question on the floor was about objections. And there's a trial advocacy program I know that has an all objection rule. Everything that you object to everything to help students and participants in the program get immune, get comfortable, get used to being objected to. Because I think that if there is anything trial lawyers fear, it is that objection, like everything sort of freezes. The person just feels like, how dare you object? And of course, many times it's abused. Many times lawyers will object to things just to get their clients breathing space, just to get them out of tough corners. So there's the ethics to objections, but the purpose of objections is to keep a process fair, because we all know that there are rules that we subscribe to when we are in court. And an objection is the civil way in which we raise complaints about what is happening, to call court's attention or opposite side's attention to the rules. So what I have always done as a practice, as in my practice, is that every time I hear objection from the other side, I always write down the last thing I had said before we said objection. Because many times the process of resolving the objection is going to upset me or throw me off the cuff. And I want to be able to come back to that point before the objection and proceed as though it had not happened. I want to be able to come back and say, yes, so my question to you was this. So whether it is an objection to the testimony of a witness, to the questions as a witness testifies, or it is an objection to a document or exhibit that is trying to be put on the record of court. A lot of these objections you can foresee for yourself just by being alive to the rules and testing your own evidence and preparation. And this is where preparation again comes in. So for example, if you think about all the objections that are usually raised against exhibits, if you would analyze each of your exhibits against the rules on admissibility, on relevance, on primary and secondary evidence, you yourself would catch the reasons that opposite counsel is going to be raising against your document, so that you resolve them and don't have to wait for people to object to your evidence. Or you can just make sure that your evidence, you've prepared the reasons and the arguments that will persuade the judge to allow and overrule the objections on the other side. So I think that the best way to approach objections is to be the devil's advocates in your own cases, so that you prepare with that other eye to identify what is going to be objectionable, so that you can prevent it if you can, or prepare to respond to objections ahead of time. And since we really made that good judge miss his meeting with the principal judge, we might as well milk as much as we can from his presence here by turning to him now.
I need protection. Yes, objections.
Yeah, so I can go on and on, but I would really love to get it.
Thank you. We are constantly learning from one another. I've just learned something which I like, and I believe everybody must have picked that you write down the last question that you had before the bullet was fired. Remember in your graveyard, when you're dying, what was going on, the dying declaration. It's very easy for you to forget what was going on, because I can tell you free of charge, that moment of objections is another battlefront. So objections can come in two forms. They could be written by way of a notice of preliminary objection, which gives you room to prepare your reaction, your response. And when it comes in form of written by over notice, many a times you'll find it has its fountain in the pleadings. So that the most common types of objections that we encounter are related to the Law of Limitation of Actions Act. Somebody has raised a preliminary objection on a point of law that the suit is time-barred. Another very common example is a question of jurisdiction of the court. Another one would be the doctrine of exhaustion, that you have not exhausted remedies in other fora before coming to court. So you'll have preliminary objections coming in all manner of forms and styles. So it's upon you to know how to react, how to respond to the notice, so that your case does not drown, because we know the story of Mukisa biscuits. The preliminary objection will sink your whole case. And as I speak to all this, I would like to remind us that indeed, right from where we started, the conversations that Linda started off with, peace, preparation. If you are doing a good prep, if you're doing a good case analysis, you'll be able to very early in the day eliminate potential notices of preliminary objection. The other very common form of objection is the one that you find on your feet. When you're on your feet, when your opponent raises it and says they want the court to determine the objection before the case can proceed. They could be related to the law, but most of them will probably speak to substantive law, but most of them will speak to procedure. And it happens usually during cross-examination. Objection, Your Honor. Sustained. Objection, Your Honor. Overruled. Objection, Your Honor. Why? He's asking the wrong form of question. Sustained. Counsel, rephrase your question. Objection, Your Honor. Sustained. So you'll hear it becomes a platform of, no wonder Linda was saying she writes down the last question, because it can become murky. So that what do? You must not lose your drift. Hold on to that which you are doing as you react to the preliminary, to the objection as it's raised. Many a times it's ill-motivated. And the advocates who we say are thriving in fear are the experts in objection raising. So when you see a case which has too many objections, I've come to a conclusion that that is an advocate who is trying to drown the big ship using bows and arrows. Woe unto them. What is the court's role in all this? The court will read mischief where it belongs, when it's coming in the direction that the mischievous counsel intended. So the court will normally flag you down, tell you enough is enough, and tell you that it does not uphold that kind of approach to procedure. So what happens when an objection is raised? Counsel who is raising it is under a duty to tell the court what the objection is all about. So it becomes a trial within a trial, because the other counsel has then to respond. And once they respond, you'll find that the court ultimately renders itself by way of a ruling. So that what must you do when a preliminary an objection is raised when you're on your feet? Courtesy and etiquette speak to the fact that you must sit down. When your opponent raises an objection, humility calls for you to occupy your seat. Do not fight back. Let counsel who is raising the objection push the objection through, and only then must you stand up and react. do not antagonize counsel when they are raising their objection. The effect of you interfering with an objection being raised by counsel is that you compromise your credibility. I would rather the calm advocate who is not a warrior fighting at the level of the PO being raised. Take your time, listen, digest, and speak last with authority. Remember, you cannot argue an objection together with the other person raising it, the other advocate raising it at the same time. One of you must sit and listen, and that must always be you, so that you are able to digest the question and give a tangible answer. Thank you very much.
All right, thank you very much, Justice Chigiti. We'll go to the last question for today before we get into the Q&A session. And the last question is about the manner which advocates can balance their duty to their client, as well as their ethical obligations to the court and to the legal profession. And we can start with Ms. Alinda before we finish with the judge. Ms. Alinda, thank you.
Wow. You know, after you have fought so hard to win a client, I'm sure Justice Chigiti no longer remembers this hassle. But you have all these commitments that you make to clients. Client is king, the client is, what the client wants is what the client gets. So it's quite a paradox to then get into the courtroom and be an officer of court. But I think that as a young person and as a practitioner, you have to always remember that there will be many clients. There will always be one bench and one bar where you sit to serve those clients. And so your credibility and your integrity is a currency that you cannot compromise. Because while you can get another client, you cannot get another you. You cannot get another reputation. You cannot change how people view you or repair trust once it's broken. And I think that the realization of that makes you or makes the decision on your duty to the court a lot more objective, a lot more focused, a lot more non-negotiable. And at the end of it all, we are all just trying to get justice. What justice means might not be in your client's favor today, but you know, we are all interconnected. It's still one world, it's still one economy. We have to make sure that the ecosystem is for justice, because you don't know when you will need good old justice to come to your rescue. And so when you serve as an officer of court, that's why your duty first and foremost is to the court. And I like to ask my students so many times, why do we bow? Why do we bow at the beginning and at the end of court? And even deeper, who do we bow to? We bow to the judge. We bow to Justice Chigiti. If you reverse this and thinking about it in terms of the church, because a lot of our traditions are similar to those of the church. When you go to church and you bow before you get out during a service or as you leave, who are you bowing to? Are you bowing to the priest or to the altar? You're bowing to the supreme idea, to the reason why we all practice law, to justice. And whether or not I like Justice Chigiti, whether or not I like his ruling as he's just given it to me, I'm still an officer of this court. And he wields that power on behalf of a greater purpose that we all subscribe to. So I think that you have to think about your duty to the court through those long lenses. 10 years from now, you're still going to have to practice. And the decision that you take today to present false evidence, to let your client lie, to steal documents from a court file, to torture a witness, to tell the court a lie, to promise your land friend one thing and then do another before the court. That's very common with you young lawyers. Counsel, don't worry, I'll get an adjournment. It's okay, you are stuck, it's okay, let me handle it. My lord, opposite counsel has served, there is an affidavit of service on the record, looking around and he's nowhere to be seen, I therefore make an application for dismissal. You don't know where you're going to meet that advocate next time. Eh? Your duty to the court and to your land friends, despite the fact that they don't necessarily pay your bills and keep your doors open, is what keeps you in business. You want to enter a transaction and watch the odds rise in favor of your client. I've been in court where the judge says, Linda, are you sure about your client? Because I'm doing this for you, not for your client. Hey, and in that moment, I have to ask myself if I'm really sure. But then also, there's something that a very senior lawyer once said to us when we were in law school. He said, every time you go against ethics, you start to attract those people that are unethical. So if you go, for example, and bribe a judge or offer a bribe to a judicial officer in one case, because your client has asked you to, guess who he's going to tell? His other clients that also need that same service. And the same way other lawyers are attracting business because they are very good at what they do. This is what you're selling yourself out as very good at doing. So you're going to, he will go and tell his other friend, I may have a lawyer who can go to the judge. And before you know it, you're the lawyer, you're the one that people come to when they want those unethical things. And it's never sustainable. It always runs out too quickly. I've had the benefit of sitting at the feet of very old lawyers all my practice life. And the one thing they tell me is that there's always been unethical lawyers. But when they look around 30 years later, 25 years later, those lawyers have had to go to farming, to go to real estate, to go to some other business, but not the practice of law. Why? Because trust and credibility are major currencies that our profession needs, and you will compromise them if you don't uphold your ethical duty to the court. That's my 2 cents.
Thank you, Ms. Alinda. We'll go on to the good judge to finish us off on that bit. If we have an additional, some additional advice on how to balance our duties between the court and the client, as well as the legal profession.
So, thank you. One thing that we all know is that we are all born free and equal in rights and dignity. That's Article 1 of the Universal Declaration on Human Rights, 1948. So all this conversation that we're having here is all about access to justice. It's all about our dignity and equality and non-discrimination. So whether you are the bar or the bench, we must at all times remember that it all meets at the altar of equality, dignity, and non-discrimination. It's about the rule of law. That's why we are lawyers. We have our role to play. However, now, we must always remember that we cannot discharge our mandate without interacting with our colleagues, the courts, the bar, so that the question must always be, whatever I do, Is it for the good or is it for the bad? For your nation, for access to justice, for dignity, for equality? Because that little thing that you do will impact somebody somewhere, one way or the other. So that when you look at the client, you look at the court, you look at the bar, you ask yourself, how would it be without you? And the answer would be, if it's not going to grow without you, there's a problem. If it grows with you, it's a good entry. So what value are you adding to your clients, who are the citizens who, like in Kenya, we call Wanjiko, the people that we serve as advocates? What value is it going to add if you're going to court to lie? Why did you become a lawyer? Your father, your mother sold all the Nyankole cows to take you to the law school, and here you are busy stealing from the court. Your parents sacrificed in order to ensure that you got your fees at the law school. But the best you can do after becoming an advocate is to play mischief and lie to the court. It's useless. It has no value because it will affect posterity. It will affect the future generations. So what kind of seed are you planting today? Ask yourself about your integrity. Speak to yourself. Nobody will speak to you. You know yourself. How clean, how tidy are you within? How do you get your things going? Do you use money? Do you bribe your way through? Is it necessary? When is your expiry date? It has no value. Do it the right way. No matter how nice your client is, no matter how much fees he's paying you, tell your client that you're an advocate who believes in honesty. Because at the end of the day, even if he pays you how much, no matter how big a house you purchase, no matter which car you drive, no matter where you go for your holidays, your credibility shall forever haunt you if it's in the south direction. So as young lawyers, start very early. Build your credibility from the cradle, from very early in the day. It's very hard to rebuild it once it's lost. Consistency. How consistent are you to the court? Do they see a rainbow in you? Do they see a multiplicity of colors in the way you present your cases? Today, you're going east. When you appear tomorrow, you go south. Day after, you're going west. You're unpredictable. That is not a good way to practice. Remain consistent. Let the judges see the North Star in you every time you stand up. Let your colleagues see a North Star shining the way for them. Let the bar respect you always. Let everybody say that that's a person to go to whenever there's a question. He is consistent. He is reliable. We are lawyers. We are notorious in our ways. Let us shed that skin and dress in the consistency gear, which must be the gear of wisdom, success, and victory in our courtroom. Be motivated at all times, even as you discharge your obligations, your duty to court. Walk with confidence. Let the court generate jurisprudence because of the motivation, the quality that you donate in your submissions. As you discharge your client's mandate, don't just celebrate the fees, celebrate the victory in the jurisprudence that you help develop. As a young advocate, a time has come when you stopped reading judgments by Philip, judgments by Elizabeth, judgments by Linda, but start reading judgments generated by you because you have done hard work. And I can tell you free of charge, if you embrace that gear of consistency, motivation, honesty, integrity, credibility, you shall be a superstar at the bar. Let them laugh at you, but at the end of the day, he who laughs last shall be you. You shall laugh the best. Hard work, patience. Don't be in a hurry to achieve everything overnight. Don't be the microwave lawyer who cooks everything in minutes. Don't be the instant coffee counsel. Invest, develop, improve, make it better. Let it last. Build your pyramid. Carry those big stones with methodology as you develop the big pillar in the pyramid that will stand tall in Cairo, in your courtroom, in your bar platform, in your society, in your community. Let them look at you and see that icon which you built. It starts with you today. And trial advocacy is a big tool that will give you the engine power, that will give you the authority, that will give you the oil that will facilitate your growth. We do trial advocacy training. We have one coming up in April in Kenya under the Trial Advocacy Training Institute. Do not miss the bus. There we go, flyer flying away. Do not miss this bus. You will never regret. For me, this is the greatest investment I made in my career in 2010. I know you can. Ask yourself why we are still preaching this creature, trial advocacy today. Linda, maybe you want to pick from there. I give it to you. I donate my time to you.
I just love how so in sync we are, because I was just looking for this flyer so I could put it up. And I'm just impressed that you also took it in 2010, because I took it in 2010 as well. How many years were you at the bar when you took the training, Justice Chigiti?
I think I could have been around 9, 10 thereabouts.
Imagine Justice Chigiti took the training when he was 9 or 10 years at the bar, and I took the training when I was 2 years at the bar, and we both think that it was the biggest turning points in both our careers. And Justice Chigiti recently said on a platform where we are together that you'd rather, you see, right now in this meeting, when we're talking about trial advocacy, we've been over 350, and we've spent only 2 hours. But for those trainings, you usually can only be at most 40 people, and you take at least 4 days honing these skills. And you'd rather have one person trained. I think Justice Chigiti, I told you should write that down as a saying. You'd rather have one person that is trained over the 4 days of this program than have 400 that have only attended these 2 hours of this conversation and think that they are now trial advocacy experts. So my parting shots would be: invest in your trial advocacy skills. And the one training that I know that is dedicated to doing that, using the learning by doing methods, is this trial advocacy training program. And in Kenya, it's run by the Trial Advocacy Training Institute. Please join. Please become a member of this tribe. Please commit every day to the things that you're doing.
Thank you. It's done in person. Sorry, Linda, I cut you short. I got excited.
No, go ahead. I was done.
Thank you. It's in person. You get to shake hands. You get to shake a leg. It's fun. We play games. We sing. We dance. We tease.
Yeah.
Oh, man, I can't go on. Don't miss the flight.
Yeah, so that's what we would both spend our last minutes on. Over back to you, our panelists, before you charge us for the advertising.
Thank you, Linda. Thank you, Senior Counsel, the good judge. But as a way of lobbying, I always ask out that maybe you could partner with the ELS Institute to have an online training for the members, because I see there in the chat session, there are already people asking if you can have an online training session. I have done that session, and I can tell you it is magic. There's someone who was saying intimidation by senior advocates is one way of creating fear. Trust me, if you have this training, I'll give a story. The first time after this training, I appeared in a court in Mubende, and there was this upcountry council who was the king of the place. And everyone had told me that guy is going to tease you. Trust me, I took him on. I actually had no robes, and he told me, the judge is going to lock you out. You're not going to do anything. I surprised him, because when I reached court, I just asked the judge that, I just prayed that court sees me the way I was, because I had come to take instructions. And surprisingly, there was a hearing that was ongoing. So the judge allowed me, but it builds confidence. It builds perfection. You don't take things for granted after this session. I have seen people saying they have not practiced, there's a lot of submissions. Trust me, if you have this training, when you appear before any judicial officer, I think it is written from the onset that they'll give you space to practice your art. Thank you, the good judge, for sharing that flyer. I believe so many people will come through. And like I said, I always ask the secretariat that we follow up and have such trainings for our young lawyers or members of the fraternity, so that they don't miss out on such skills. I'll hand over to Elizabeth. Good enough, so many questions have been answered during the session. Maybe if you have one burning question from a participant that can put up his or her hand before I hand over to the moderator of the day. Otherwise, thank you.
Right, thank you, Philip, for that. I believe most of the questions have been dealt with throughout the session. And because we are a bit out of time, I guess we'll have to close here and just give a brief vote of thanks on behalf of the East Africa Law Society, and on behalf of the participants and the audience today. We want to say thank you to Justice Chigiti and Ms. Alida Ikanza for the training that we've just had. It was really informative. I'm sure everyone has picked up a few things to use before they come for the actual training. We're hoping to all sign up for this training. And we'll just want to sincerely say thank you and wish to see you in future trainings for the East Africa Law Society and even other forums. I think we can stop there for today. Have a good evening.
Thank you very much.
Thank you.
Thank you. Thank you, friends. Thank you,
And
panelists.